Good evening, ladies and gentlemen. I'm Hazel, Dean of the Faculty of Laws, and it is a great pleasure to welcome you all here this evening. I am absolutely delighted to be presiding as Dean over John's inauguration as Quain Professor of Jurisprudence. I think it's a tribute to John that the audience tonight is studied with some of the greatest jurisprudence stars, and of course many old friends of the faculty. The Quain Chair of Jurisprudence is very important to the faculty, and it dates back to a bequest in the 19th century. The chair is devoted to the study of legal philosophy and has been held by some of the world's most distinguished legal philosophers. Ronnie Dworkin, who's here this evening, a giant of legal and political philosophy, held the Quain Chair from 1998 to 2005. Other distinguished holders of the chair include Glanville Williams, Lord Lloyd of Hampstead, whose Lloyd on Jurisprudence introduced 4 decades of law students worldwide to jurisprudence. William Twining was a holder of the chair, now Emeritus Quain Professor of Jurisprudence. His influence on academic legal education in the UK, USA and elsewhere has been absolutely immense. Jerry Cohen, the internationally distinguished moral and political philosopher and former Chichely Professor of Social and Political Thought at All Souls, was a highly successful visiting Quain Professor for 2008-09 until his untimely death in August 2009. John Tasioulas, I am sure, is going to demonstrate this evening that he is a most worthy holder of the chair. It gives me great pleasure to have him give his inaugural lecture this evening. But before we ask him to do that, I want to hand over now to the President and Provost of UCL, Professor Malcolm Grant, who will introduce our chair for this evening. Malcolm.
Well, thank you very much, Hazel. On behalf of the whole UCL community, it gives me enormous pleasure to welcome everybody here tonight, knowing the great distance that many have travelled to join us here on a wet night in London, but for intellectual fireworks. The ceremony of an inaugural lecture is part of the punctuation of a university year. It's an opportunity to celebrate the appointment of a distinguished individual to a chair, but also an opportunity to hear them to profess. Professors should profess, and an inaugural lecture is the opportunity to do it. It's not the first lecture the professor's given. Indeed, it often comes a significant way through a distinguished career, nor, John, is it the last lecture. I do recall a Cambridge colleague who gave his inaugural lecture 2 years after he'd retired, because it was the first time he'd had time to think about what he wished to say, crowning a hugely undistinguished career. But that's not at all the case tonight. There were 3 Quain brothers, 2 brothers and 1 half-brother, at UCL in the late 19th century. One of them, Richard Quain, was an anatomist. He came to UCL and in 1832 was appointed as a demonstrator, and he spent his professional career at UCL. He died in 1887 and left what was a princely sum in those days of £75,000 to found 4 chairs at UCL. 2 others are presently occupied. One in physics is occupied by Gabriel Apley, a nanotechnologist, and another one in English language and literature by Rosemary Ashton. Now, the Quain Professorship of Jurisprudence is the 3rd. The official historian of UCL expressed the following opinion of Richard Quain. He said, "He died in 1887, leaving his fortune to the college. He was a violent partisan and a difficult colleague." So no change there. His published work was chiefly anatomical. Many stories are told of him. It is said that he used to go round his wards with his hands deep in his pockets and his hat on his head, and that he had a particular dread of hemorrhage. For a surgeon. He cannot be said to have been a great surgeon, but he was certainly much respected in the medical world. That was before the compulsory annual revalidation of doctors. But so much for the heritage, and I mention it only to demonstrate the powerful impact of philanthropy and encourage everybody to follow the generous example of the Quain brothers. But my real obligation and duty and pleasure tonight is to introduce Onora O'Neill. Onora has held many of the highest offices as President of the British Academy and Chairman of the Nuffield Foundation, but those are not empty trinkets, they are reflections of an outstanding career as a philosopher. Somebody whose work has been widely read and understood, not only to specialist audiences, but also with huge public accessibility, particularly through the memorable Reith lectures on trust. And in present circumstances of government global breakdown, a recurrence to the theme of trust and governance is particularly timely. Of all Onora's great accolades, the one which gave me greatest pleasure was to confer upon her an honorary degree of UCL. So, Onora, we're delighted to welcome you back tonight, and thank you so much for presiding at the lecture. At the conclusion of the lecture, it's not customary for us to take questions, but I will formally inaugurate the Quain Professor at the end of the lecture. Thank you.
Thank you, Walter. President, Provost, ladies and gentlemen, friends and colleagues, John. This is a great pleasure for me and an honour for me to introduce John Tasioulas on the occasion of his inaugural lecture as Quain Professor of Jurisprudence in the Faculty of Laws of University College London. I've known John and some of his work across, I suppose, about 15 years, and I quickly realised that his intellectual enterprise is both distinctive and highly coherent. One way in which the distinction is revealed is rather obvious. There is a glittering academic trajectory, beginning at the University of Melbourne, where he read both philosophy and law, continuing as a Rhodes Scholar in Oxford, followed by time as lecturer in jurisprudence in Glasgow, when I first came to know him, before his return to Oxford, and of course his election to this very distinguished chair here. But I think the nature of his distinction shows more plainly in the fact that in the years before his election as Quain Professor of Jurisprudence, he was reader in moral and legal philosophy in the University of Oxford. Now that may not seem a surprising combination. There are numbers of highly distinguished colleagues in the English-speaking world, however, who work in political and legal philosophy or in political and moral philosophy, but there are very few who would say that they work in moral and legal philosophy. And John has been unusual, I think, and distinctive in that narrower sense of the term, in his sustained commitment to working both in legal and in moral philosophy. I don't think that dual commitment would have seemed at all unusual in earlier times. Discussions of justice and virtue, of law and morality, were constantly linked in classical authors from Aristotle to Locke, and indeed, let us note with appropriate piety, by Jeremy Bentham. But this link has been far less evident during the last century, during which many of those working on conceptions of justice have been quite reluctant to argue for, even to discuss, let alone profess, moral positions, and keen above all to assert and protect the choice and rights of individuals, whatever their choices. Nowhere is that separation of considerations of justice from morality more evident than in John Rawls's later work, in which he defended a position that he terms political liberalism. Now, to those of you who don't do political philosophy, that may sound the merest tautology. What is liberalism but a political position? But it had a very particular inflection in the work of the later Rawls. It was used to characterize, it is used to characterize, a distinctive form of liberalism that defends an institutional framework that protects individuals' pursuit of their individual conceptions of the good, but that is itself, to use a famous phrase, agnostic about the good for man. Many leading contemporary writers on justice have had nothing to say about the good or about virtue, and indeed have taken quite a pride in their agnosticism about the good. John Tasioulas is notably not one of them. He has, of course, written widely on many themes in the philosophy of law, but he has also written extensively on moral objectivity and moral relativism, on mercy and repentance, on clemency and dignity, and many other themes. And I think that with this breadth of interest, it's hardly surprising that he's come to think deeply and critically about human rights. This is, in my view, quite rare. It's becoming more usual, but it has been quite rare. One might be surprised at that thought, because human rights are, of course, central to the dominant ideology of our age. They are certainly the best entrenched and overwhelmingly the most discussed aspect of justice, and indeed, on some views, justice is merely a matter of respect for human rights. Unfortunately, in this broad consensus that human rights are of profound importance, they are all too often defended only by appeals to arguments from authority, the authority of charters, conventions, constitutions, and the like, and they often lacked philosophically adequate analysis or defense. John has titled tonight's lecture Towards a Philosophy of Human Rights, and I'm sure we're in for a serious treat. John.
Well, thanks to Hazel, Malcolm, and Onora, and it's wonderful to see so many people here tonight. Students and former students, colleagues, former colleagues, friends. I won't say former friends. I'm very grateful to Onora for agreeing to chair this lecture. Onora has been an inspiration throughout my academic career, not only because of the depth and power of her writings on moral and political philosophy, from which I, like so many others, have learnt so much, but also because she personifies the union of principle and wise judgment that is a central theme of those writings, and that is an even more precious quality. Anyone coming to the Quain chair is bound to feel rather daunted by its stellar list of previous occupants. And of course, in my case, there's sadness as well because of the tragically premature death of my immediate predecessor, Jerry Cohen. I remember Jerry from my time at Oxford as an electrifying presence on the philosophical scene. And in recent years, I resonated strongly to his idea that justice is one political value among others, and that the failure to recognize this threatens to impair our grasp of justice itself. He is sadly missed. 2011, the year in which I was appointed to the Quain chair, was the 50th anniversary of the publication of H.L.A. Hart's great book, The Concept of Law. Dostoevsky is supposed to have said of his generation of Russian writers that they all came out from Gogol's overcoat. There are at least two generations now of legal philosophers in the English-speaking world who can say the same about the concept of law. I certainly would not have become a legal philosopher but for my encounter with Hart's work as an undergraduate in Melbourne, and I count myself very fortunate to have known him during my time as a graduate student, because he too was truly good as well as great. As if this were not enough to underscore the tremendous indebtedness of legal philosophers of my generation, 2011 was also the 25th anniversary of the publication of three other canonical works: Ronald Dworkin's Law's Empire, Joseph Raz's The Morality of Freedom, and James Griffin's Well-Being, Its Meaning, Measurement, and Moral Importance. And I'm very honored by the presence here tonight of Professors Dworkin and Griffin. Although given what I'm going to say later on about their views on human rights, I must confess to some relief that the format of these inaugurals does not include a question session. Our attitude to great works like the ones just mentioned should, of course, be one of admiration and gratitude. But it should not be, in Ronald Dworkin's evocative formulation, one of unstudied deference to a runic order. Instead, we must, as best we can, engage with such works in the same spirit as that in which their authors wrote them, as contributions to an ongoing dialogue aimed at discovering the truth. But the truth is inexhaustible, our grip on it is fallible, and in any case, the truth has to be won anew by each generation in light of its own problems and concerns. There's no guarantee of success, but given the importance of the questions, every effort that has even the slightest chance of edging us forward is surely worth making. We owe our illustrious predecessors and ourselves nothing less. Let's get down to business then. The propensity of human beings to depict the gods in their appearance and manner of life after their own image was a phenomenon well known to the philosophers of ancient Greece. One of them, Xenophanes of Colophon, jokingly observed that horses and cows, if they had hands and could draw, would no doubt portray the gods as horses and cows like themselves. At the level of rhetoric, at least, the idea of human rights is a ruling idea of our age, one that is often invested by its devotees with a quasi-religious significance. It, too, has not escaped distortion through a similar process of projection. And so one finds lawyers who unapologetically declare that a human right is nothing more than anything denominated as such in a formally valid legal source. But this superficial view lacks both breadth and depth. It lacks breadth because many of the human rights laid down in law are not universally binding or are subject to eviscerating reservations. More importantly, it lacks depth because it passes in silence over the grounds for including any item in human rights law in the first place. A supposed right does not automatically become a genuine human right by being set down in an official instrument, however impressive or widely adhered to, any more than a judicial decision constitutes a requirement of justice simply because it's issued by a body designated as a court of justice. This crude legalistic reduction of human rights fails on its own terms, since the human rights laws to which it appeals typically presuppose an independent conception of human rights, one that is a benchmark against which the laws themselves are to be assessed. Now, it's no great improvement on this know-nothing legalism to construe human rights as embryonic legal rights of a certain kind, legal rights in waiting, as it were. As Amartya Sen has powerfully argued, incarcerating human rights within a legal framework obscures a tremendous diversity of ways in which such rights are given shape and force in everyday life. These include extra-legal channels through which ordinary citizens and NGOs, like Amnesty International and Human Rights Watch, bring pressure to bear on governments. Later, I shall return to the limitations of conceptually tethering human rights to some institutional structure or role, whether legal or not. But let me first introduce another tribe that has displayed unmistakable projectivist tendencies in relation to human rights. Philosophers are relative latecomers to the contemporary human rights scene, and perhaps because they lack the institutional clout of lawyers, they have not so much asserted ownership of human rights as the authority to preside in judgment over uses of the concept. Too often, however, the source of this authority has been the claim to possess what philosophers, exhibiting, it must be said, an uncharacteristic forbearance, like to call a theory. Normally, this is a theory of morality in general, one that presents all moral thought as grounded in a single master principle or a small set of principles systematically ordered in advance. But it might be instead a general theory of the nature of rights, one extracted by hard labor in the Hofeldian salt mines and invoked as a template to which human rights discourse must conform. For those like myself who are inclined to be skeptical of the prospects of theory of this sort in morality, an attitude, I should stress, which is by no means equivalent to skepticism about the claims of morality itself, this is a dubious basis for asserting intellectual oversight regarding any domain of practical thought. Because much philosophical work on human rights is mediated by this fixation on abstract theoretical structures, it often results in a disappointing non-engagement, a failure to bring into focus human rights as that notion is understood in the wider culture in which it has its home, thereby depriving itself of the capacity to exert any critical leverage on this culture. Symptomatic of this failure is the commonplace spectacle of philosophers endorsing only very few of the rights in the Universal Declaration of Human Rights as genuine human rights. So, when the greatest political philosopher of the last century, John Rawls, inadvertently gives comfort to authoritarian and repressive regimes throughout the world by approving a severely truncated list of human rights, a list that makes no room for human rights to non-discrimination on the grounds of sex, race, and religion, no room for human rights to freedom of opinion, speech, movement, and political participation, no room for human rights to education, work, and an adequate standard of living, and instead classifies all these excluded rights as liberal aspirations, it's very hard to shake off the suspicion that he means by human rights something very different from what, on any halfway charitable construal, most people, including the Declaration's framers, mean by that phrase. Although both lawyers and philosophers in my admittedly cartoon-like sketch have engaged in different forms of projection, their images of human rights share an important feature. Human rights are understood rationalistically as consisting first and foremost in a set of principles, a code of conduct. In the case of the lawyers, these principles possess or are to be given a legal institutional embodiment. In the case of the philosophers, the principles form part of the broader web of propositions that comprises a theory of morality or some segment of it. Of course, the source of rationalism's allure differs in each case. For the lawyers, a large role is played by the bureaucratic imperative in favor of standards that can be applied without extensive reliance on the exercise of moral judgment in order to facilitate predictable social relations. For the philosophers, a significant, if unacknowledged, motivation is the ambition to mimic the explanatory achievements of the natural sciences, albeit by adhering to a model of rational inquiry that is very probably an inaccurate interpretation of a defunct scientific paradigm, that of Newtonian physics. In any case, one reason the idea of human rights belongs to neither the lawyers nor the philosophers is that it does not ultimately consist in a system of principles, but in a distinctive ethical sensibility. And this sensibility exhibits a number of hallmarks. The idea of each and every individual human being as an ultimate object of moral concern, that the concern in question can take the form of recognizing moral duties that are directly owed to these individual human beings, who have corresponding rights to their performance, that in virtue of our standing as human beings, equipped with the capacity to realize certain values in our lives, we each equally possess rights, independently of whether or not they're actually enforced or even recognized socially. And intimately bound up with these ideas are sentiments, such as those of blame, guilt, resentment, that give shape to notions such as that of a duty or its wrongful violation, and also some sense of the elements that conduce to a good human life and the threats to their realization. This sensibility, of course, is embodied in a wider culture of thought and practice, one that law and philosophy must presuppose and draw upon in pursuing their practical, institutional, and explanatory theoretical projects. Now, in fairness to the philosophers, many of them have recently acknowledged the merits of what is often called a bottom-up approach to human rights, one that starts from an established practice, in contrast to a top-down approach driven by the potentially extraneous concerns of philosophical theory. But even these philosophers often frame their engagement with human rights in terms of an overarching concern with what is said to be an out-of-control proliferation of human rights claims, one that threatens to debase the currency of human rights. In response, they present themselves as curing this pathology by injecting a much-needed element of quality control. Now, there are many reasons for entertaining misgivings about this proliferating talk about human rights proliferation, even if we can get past the faintly comical image of a solitary philosopher, King Canute-like, seeking to roll back an onrushing political tide of global proportions. These misgivings also persist, even if we put aside the fact that those who complain about proliferation often fail to make clear whether they have in mind human rights, understood as moral standards, or as legal norms. After all, although human rights law characteristically seeks to embody and implement human rights morality, something's being a human right in morality is neither a necessary nor a sufficient condition for enacting a legal human right with matching content. But even if we confine ourselves to the morality of human rights, it's not as if we have some firm independent grasp of how many human rights there are, or even how to count them. In line with our initial religious analogy, some philosophers appeal to a trinity of fundamental human rights from which the others derive, while others of a monotheistic bent invoke a single master right. But in this numbers game, we should be careful not to confuse parsimony with intellectual rigor, so that fewer is even presumptively equated with better. Another thing worth noticing is that philosophers' talk of proliferation often reflects an unappealing mixture of intellectual condescension and lack of interpretive charity. So, for example, the philosophers who lament the proliferation of human rights claims predictably reserve their most scathing remarks for Article 24 of the Universal Declaration, which notoriously states, "Everyone has the right to rest and leisure, including reasonable limitation of working hours and periodic holidays with pay." Now, personally, I've always been rather fond of this right, coming from a Greek and an Australian background. It's just the fact that one of the few points on which these two great cultures converge is the vital importance of leisure. But for those inclined to share the philosopher's disparaging verdict, I recommend as an antidote Jeremy Waldron's eloquent defense of the right to rest and leisure in his book, Liberal Rights. At most, the article's specific reference to periodic holidays with pay can be faulted for conflating a particular mechanism of implementation with the human right itself. But that is hardly a fatal error, given the wider aims of the Universal Declaration, which go beyond enumerating human rights to proposing effective means for their social realization. Now, even if proliferation is a misplaced focus of ultimate concern about the contemporary human rights culture, a critic might insist on a deeper problem. The problem that it is far from clear within that culture, first, what it means to assert that something is a human right, and second, on what grounds anything gets to be a right of that sort. Proliferation, to the extent that it's a problem, is a symptom of this underlying lack of clarity about the nature and grounds of human rights. Now, although there is merit to this line of thought, no compelling reason has been given for supposing that talk about human rights is in notably worse shape than talk about justice, fairness, or equality. There is perhaps simply just more of it around. Moreover, the demand for clarity cannot be limited to supposedly marginal or novel human rights claims. If we need to get clearer about the nature and grounds of human rights in general, then this must apply just as much to the human right not to be tortured as to the right to rest and leisure. Now, in this lecture, I want to address two broad ways in which philosophers have, on the whole misguidedly in my view, tried to instill greater clarity and rigor into human rights discourse. The first way, which I shall call foundationalism, imposes significant restrictions on the values that can ground human rights claims. It constrains the input into arguments for human rights. The second way, which I shall call functionalism, characterizes the very nature of human rights in terms of certain institutional functions. It constrains the practical output of human rights. And my contention is that the constraints sponsored by the foundationalist and the functionalist moves backfire, distorting the significance of human rights. In the meantime, the point at which the need for greater clarity and rigor is most acute, the very difficult question of how we get from the values underlying human rights to establishing a human rights claim has tended to be neglected. By making progress with this problem, which I shall call the problem of the threshold, I believe we'll be better able to see the foundationalist and functionalist gambits for what they are, straitjackets that constrict rather than enable our thinking about human rights. So let's turn to foundationalism first. Perhaps the most egregious manifestation of the foundationalist tendency involves the rejection of an apparently irresistible inference. The inference begins from the observation that almost any credible candidate to be a human right protects some universal human interests. The human right to a fair trial protects our interest in liberty. The human right to health protects our interest in health, and so on. From this observation, it's inferred that human rights not only systematically serve to protect human interests, but also owe their existence to the fact that they do so. It's not a coincidence. To this extent, human interests will be among the grounds of human rights, even if they are not exhaustive of those grounds. To this extent also, any sound account of human rights is interest-based. Now, according to some philosophers, this seemingly natural inference to an interest-based view of human rights is radically mistaken. The primary grounding of human rights cannot be interests, they claim, because there is a radical discrepancy between the moral logic obeyed by interests and that obeyed by rights, including human rights. The moral significance of human interests is exhausted by moral reasons to maximize their aggregate fulfillment across persons. In the process of maximizing the fulfillment of interests across persons, it will often be necessary to sacrifice one person's interests to another's. In other words, the view is utilitarianism captures the moral significance of human interests. But these philosophers go on, the distinguishing feature of human rights is to erect powerful, if not absolutely insurmountable, barriers against trade-offs of this sort. From a purely interest-based perspective, they say, there's no reason not to kill one, there is reason to kill one innocent person in order to prevent 3 other innocent persons being killed by someone else. But precisely this is what the logic of rights rules out. The recognition of a human right to life is the recognition of a barrier against trade-offs of precisely this sort. So these philosophers conclude the primary grounding of human rights is in the status, the moral status of their holders, their status as members of the moral community, not in their interests. Now, one problem with this view is that the notion of moral status seems to be over-inclusive. It surely lies at the root of interpersonal morality generally, informing even departments of morality not centered on rights, such as charity and mercy. It therefore cannot by itself serve to isolate that segment of morality which consists in human rights. Thomas Nagel, a prominent defender of the status-based view, implicitly responds to this challenge by arguing that the relevant notion of status can be elaborated by reference to the possession of certain moral rights. So we began with moral rights. The claim is they're grounded in status. We want to know what status is. Nagel says we articulate the notion of status by reference to rights. To the inevitable complaint that this is a circular argument, Nagel's reply is that we should bite the bullet. The anti-utilitarian logic of human rights demands that they be regarded as fundamental in our moral thinking. And it follows from this that there is no other independently graspable moral idea from which they can be derived. Any attempt to articulate their grounds, therefore, will inevitably appear question-begging. Acquiescing in this circularity, however, comes at a steep price. One measure of the cost is the consequent obscurity involved in telling just when a proposed human right really is integral to our status as moral persons and when it is not. Into this logical vacuum, something is destined to rush, and skeptics will plausibly suggest that what rushes in are cultural prejudices. Hence, perhaps the alacrity with which Nagel, an American philosopher, endorses the exceptionally expansive American doctrine of freedom of speech, which treats both the public denial of the Holocaust and the use of pornography as protected by a fundamental moral right. Now, my point is not that these activities are unprotected by human rights, but that it's difficult to see how, on a status-based view, one can begin to argue the case either way. We should only pay this price if we're convinced that the moral significance of interests is exhausted by their role in consequentialist calculation that maximizes their aggregate fulfillment. But there's no compelling reason for supposing that this is the whole truth about, the whole moral truth about interests, or even necessarily part of the truth. Status-based theorists overlook or downplay the possibility of an interest-based but non-utilitarian or non-consequentialist account of human rights. Such an account does not identify human rights with the interests that underlie them, so that whatever impairs the fulfillment of the interest is in virtue of that fact also a violation of a right. On the contrary, there remains the vitally important question of the content of the duties generated by the interest. Moreover, the interests in question are not simply free-floating entities whose fulfillment is to be maximized within some aggregate calculus. Instead, they are the interests of individual people, beings that in virtue of possessing various rational and other characteristically human capacities equally enjoy a certain moral status. And one implication of that status, the status sometimes referred to as human dignity, is that their interests cannot be traded off against each other in the way mandated by a simple aggregate of utilitarianism. Human interests and moral status operate here in intimate union. The status of individuals is to be honored primarily by respecting and advancing their interests in certain ways. This conception of the grounding of human rights as interest-based but not utilitarian or consequentialist fits as a general schema what I take to be the most promising accounts of the foundations of human rights currently in circulation. These accounts reject standard forms of deontology because they regard morality as bound up with the advancement and protection of human interests. But they also reject consequentialism, according to which the overarching point of morality is to maximize the realization of good states of affairs. More than 30 years ago, H.L.A. Hart presciently observed that a satisfactory foundation for a theory of rights will remain elusive as long as the search is conducted in the shadow of utilitarianism. As we all know, the great utilitarian philosopher Jeremy Bentham was profoundly skeptical about natural rights. Hardly any philosopher now takes seriously his most frontal argument for skepticism, which is a version of the crude legalism I dismissed at the outset of this lecture, according to which rights are always the product of law. But many of those who congratulate themselves on having no truck with Bentham's legalism remain in the grip of his more fundamental tenet, namely that utilitarianism exhaustively captures the moral significance of interests. Convinced of utilitarianism's inability to make sense of human rights, they recoil into embracing a non-interest-based explanation of the grounds of such rights, one that is vulnerable to accusations of dogmatism and obscurantism. In my view, we will not put the ghost of Benthamite skepticism back into its display case where it belongs until we have abandoned the deeper assumption about interests along with the more superficial one about rights. Now, of course, not all the philosophers who adopt foundationalism do so out of fear of utilitarianism or consequentialism. Amartya Sen, for example, defends human rights within a recognizably consequentialist ethical outlook, but he also rejects the idea that human rights are grounded in interests. Instead, he takes them to be grounded in the value of freedom, in particular in human capabilities to realize certain valuable states of being and doing. Rather counterintuitively, Sen denies that freedom is a human interest. Beneath his arguments for this view, the influence of Benthamism is again discernible. In this case, it is not Bentham's moral theory that's at issue, his utilitarianism, but rather his subjectivist take on human happiness, according to which human fulfillment ultimately consists in the obtaining of certain mental states. For Bentham, the good is pleasure in the absence of pain, but other subjectivist construals regard it as a matter of desire satisfaction. Because the freedom that paradigmatic human rights secure for us does not conform to these subjectivist interpretations, Sen apparently concludes that freedom is not a basic human interest. A better response, I think, is to abandon the subjectivist construal of well-being and to embrace an objective list of basic human goods in which freedom is one among a number of goods, along with knowledge, friendship, achievement, and others. Now, in his fine book, After Virtue, Alistair MacIntyre notoriously compared human rights to witches and unicorns on the grounds they were all equally mythical. MacIntyre assumed that the doctrine of natural or human rights is a modernist doctrine, and he additionally assumed that, as such, it purports to be justified without reference to an objective conception of the human good, in accordance with what he called the Enlightenment project. But MacIntyre was mistaken about human rights being a modernist doctrine, and probably mistaken too about the nature of the Enlightenment project, assuming that the very idea of such a project is not itself to be consigned to the category of myth, along with witches and unicorns. But MacIntyre was profoundly right to this extent. The project of grounding human rights independently of the human good is doomed to failure, leaving skepticism about human rights in its wake. There is, however, another, more moderate variety of foundationalism. Its proponents accept that considerations of the human good lie at the foundations of human rights, but they restrict the universal interests that can ground human rights to a subset of that general class. According to some, only basic human needs can ground human rights, whereas others assign this privileged role to our interest in freedom. The most important contribution to the philosophy of human rights in recent times, James Griffin's On Human Rights, is an outstanding example of the second variant. Freedom, as understood by Griffin, comprises two values: autonomy, the capacity to choose a conception of the good life from a range of options, and liberty, the capacity to pursue one's choices without interference from others. And Griffin's master thesis is that autonomy and liberty are the only interests capable of grounding human rights. However, this freedom-based view prevents us from saying some perfectly natural things. The human right not to be tortured, one might plausibly think, owes its existence to the way in which torture imperils a plurality of human interests. Victims of torture not only suffer excruciating pain, their physical and mental health is threatened, as is their capacity to form intimate relationships based on trust. All this in addition to the way that torture attacks their autonomy and liberty. And arguably the same is true of other human rights. A plurality of universal human interests explains their existence. Now, Griffin resists this pluralist move on the basis that expanding the range of interests that can ground human rights undermines the determinacy we desperately need to instill into human rights thinking. But I think imposing a freedom-based constraint on arguments for human rights is no solution. Even autonomy and liberty can be imperiled in all sorts of ways without there being a human right at stake. My ability to live as an autonomous person may be threatened by a serious disease from which only I suffer and which would cost an astronomical amount of money to cure. But I do not have a human right to that cure because my interest in preserving my autonomy does not warrant imposing a duty on others to provide me with that cure, since this would presumably constitute an excessive burden on them. In other words, even a freedom-based account of human rights requires a threshold, as Griffin himself acknowledges, the threshold at which our interests in autonomy and liberty generate duties on other people. Now, the reason I depart from the freedom-based view in favor of a more relaxed pluralism about the grounds of human rights is this. Potentially any combination of universal interests can lie at the foundations of a particular human right. What ensures the intellectual rigor of the discourse is the need for that combination of interests to satisfy the criteria for crossing the threshold that's required even on the freedom-based view. The threshold that leads to the imposition of the self-same duties as owed to all human beings. Once we appreciate that the existence of a threshold is common ground between the freedom-based account and the pluralist alternative I favor, this should incline us, I think, towards the latter view for a number of reasons. And here are two of them. The first, which I've already mentioned, is that we can give stronger and less circuitous justifications of paradigmatic human rights. The human right to health will directly reflect the importance of health, not just freedom. The human right to work, the importance of accomplishment, and so on. Another reason is that the pluralist view ameliorates a problem from which the freedom-based view suffers in an acute form. And that is the potential exclusion from the protection of human rights of all human beings who are not agents, such as infants, for example, or those suffering from advanced senile dementia. Now, Griffin regards these exclusions as tributes to the sharp edges of his theory. But I think this response potentially involves a conflation of the counterfeit desideratum of parsimony, this time parsimony in the scope of human rights coverage, with a genuine desideratum of determinacy and rigor. If the justification of human rights is not exclusively tied to considerations of freedom, the prospects are enhanced for extending their protection to humans who are not agents. They will perhaps not have the full complement of human rights, but they will at least possess some, including the human right not to be tortured. Now, the needs-based view, which I won't discuss here, doesn't have the same problem regarding the extension of human rights protection to non-agents. Its problem is that standard human rights norms, including rights against non-discrimination, rights against discrimination, seem to afford levels of protection that go beyond anything that could be justified by needs alone, unless needs simply means interests, in which case the needs-based constraint is no constraint at all. Now, before addressing the second tendency I said I would discuss, functionalism, let me expand a little on the idea of a threshold, which played an important role in my rejection of foundationalism. I've already remarked upon the tendency of philosophers to justify their incursions into the human rights field under the banner of imposing quality control on the unruly proliferation of human rights claims. And the rhetorical counterpoint to the proliferation they deplore is provided by the language of minimalism. Philosophers of varying persuasions repeatedly insist that human rights are minimal standards, securing only minimum conditions of a good, decent, or dignified life. One way of understanding the foundationalist tendency I've been criticizing is as an unsuccessful attempt to make good on this rhetoric about minimalism. But the minimalism, I suggest, derives not from foundationalist restrictions, but from the threshold, the requirement that in the case of each individual, the underlying individualistic considerations of moral status and universal interests suffice to generate duties with the same content. Human rights, then, are not, on the view I'm advancing, importantly distinguished by their grounding values, but simply by their nature as universal moral rights. Now, this vital threshold mediating grounding values and duties consists in at least two stages. At the first stage, we ask whether, in the case of all human beings, it's possible to secure the underlying values through a duty with the proposed content. Sometimes the impossibility is logical. There can be no duty to ensure what someone's simultaneous existence and non-existence. Other impossibilities are metaphysical or physical. There can be no right of all human beings, including men, to give birth. Some impossibilities are mundanely contingent. There's no human right to a Rodeo Drive lifestyle, given the lack of resources now and in any realistically attainable future, to secure such a lavish existence for everyone. Some failures to meet this stage of the threshold are rather more subtle, involving what might be called directly evaluative impossibilities. Who can deny, for example, that love is one of the most life-enhancing aspects of human experience? And I mean here not an impartial benevolence towards our fellow human beings, but specifically romantic love, the kind that involves massive amounts of texting and so forth. But does it follow from this that anyone is under a positive duty to love anyone else? That there is a right to be loved romantically? Well, such a right, thankfully, seems to be ruled out at this first stage. The very nature of romantic love is at odds with the existence of a positive duty to love others. Romantic love is valuable as a freely bestowed gift, a spontaneous expression of the lover's own deepest self, rather than something one is obligated to deliver and blamable for failing to do so. By making love an object of duty, violence is done to its nature. The supposed right holder stands to receive only a pitiful imitation, and not the genuine article. But even supposing the right to love survives the first stage, it surely comes to grief at a second stage, one relating to burden. This registers the costs imposed by the putative right on the bearers of the counterpart duty, and on our ability to realize other values, including other human rights. Even if conferring romantic love could in principle be a matter of duty, we may reasonably conclude that no such duty actually exists, because the burden it imposes on potential duty bearers in terms of autonomy, spontaneity, and the strains of psychological self-policing is excessive. The supposed human right to love is admittedly an exotic case, but plausibly the same line of argument that rules it out also invalidates the claims of some items in leading human rights instruments to reflect genuine requirements of human rights morality. For example, on any literal interpretation, the right to the highest attainable standard of health fails at both stages of the threshold. First, it's not possible for the highest attainable standard of health to be an object of duty. This is because one's level of health depends on one's own decisions in a way that prevents it from being possible for others to secure for you the highest attainable standard of health, even when relativized to your circumstances. But even if we adjusted the right's content so that it refers to the provision of the highest attainable standard of health care and social conditions of health generally, rather than health itself, it would fall at the second hurdle, that of burdensomeness, since it would entail excessive costs, including unacceptable sacrifices in our capacities to fulfill other human rights. So, should we reject all talk of a human right to romantic love or to the highest attainable standard of health? Of course not, since it all hinges on the content of the supposed rights, not their labels. Presumably, there is a human right to love, but its content would primarily consist in negative duties not to impede people in certain ways in their pursuit and enjoyment of love. This is one reason why apartheid and anti-miscegenation laws are human rights violations. And similarly, the human right to health can be given an acceptable formulation, as Joe Wolfe has argued, for example, in some important recent work. Now, philosophers have not paid enough attention to the threshold question, partly because they've been seduced by foundationalism, and partly also because it's perhaps difficult to say anything both true and helpfully general about it. However, two salient features of the threshold should be noted. The first is that the process of determining the existence and content of any given right is holistic. We cannot definitively establish the normative content of human rights one by one, because in assessing the justifiability of the burdens a putative right imposes, we have to consider its impact on our ability to fulfill duties associated with other rights. The second is that it will almost always be the case that for any given right, we require a more precise specification of its associated duties, their content and their bearers, than pure moral reasoning itself will deliver. The more precise specification will be provided by some mechanism of social fiat, such as social convention or positive law. But it will be a demand of pure moral reasoning itself that convention or law take up the slack in such cases. And the convention and law must operate within rough parameters set by that reasoning. This is a point that applies irrespective of whether human rights have mainly negative primary duties, such as the right not to be tortured, or mainly positive primary duties, such as the right to health. To have a properly workable standard in each case, we need to supplement the deliverances of pure moral reasoning with publicly accessible standards regarding what counts as torture or who is entitled to what level of health care from whom. So let me turn now to the functionalist tendency. The understanding of human rights that I've been presupposing so far in this lecture is one according to which they are moral rights possessed by all human beings simply in virtue of their humanity. Conceptualizing human rights in this way renders them essentially equivalent to what were traditionally called natural rights. The second philosophical tendency I wish to discuss, functionalism, regards this equivalence as deeply misleading. Human rights, according to functionalists, are significantly different from natural rights, even if ultimately they are a subset of this latter category in virtue of possessing certain distinctive functions. So whereas foundationalism places constraints on the input to arguments for human rights, functionalism constrains their output, the practical significance that defines their nature. Now, of course, even on the orthodox view of human rights as universal moral rights, they have a defining function. They impose duties that are owed to all persons simply in virtue of their humanity. Over and above this defining function, they perform other functions, including political functions. Human rights are relevant to assessing the performance of governments, including their legitimacy, and in making judgments about the assistance we owe to people in other countries, and in more extreme cases, about the justifiability of intervening in or even declaring war against foreign states. But it's not written into the concept of a human right that they perform these other functions. one can adequately grasp what a human right is without any reference to such political roles, just as one can understand what a nuclear weapon is without reference to its political uses. Whether and to what extent a particular human right should play any political role is a matter for substantive argument. It's not something that constitutes its nature as a human right. Now, the most influential proponent of the political version of functionalism is John Rawls. In The Law of Peoples, Rawls treats the doctrine of human rights as the Swiss army knife of international political theory. Its defining functions include setting a limit to the pluralism of peoples, acting as a trigger for military intervention, setting necessary conditions for the legitimacy of any government, and also, it would seem, helping determine the upper limit of assistance those in well-ordered societies are duty-bound to provide to people in what Rawls calls burdened societies. One might reasonably wonder whether a doctrine pressed into the service of such disparate roles does not end up tearing itself apart. However that may be, one consequence of the strain is that Rawls endorses a meager number of rights as authentic human rights. So his theory was clearly not intended to make sense of contemporary human rights practice. But other advocates of functionalism defend it in significant part on the grounds that it is a better fit for contemporary human rights practice than the orthodox view. Unlike Rawls's account, the functionalist views I shall discuss are disaggregated, appealing not to a multiplicity of political functions, but rather a single defining function. In Ronald Dworkin's case, it's the function of establishing conditions of political legitimacy. In Joseph Raz's case, it's the function of placing limits on state sovereignty by specifying certain defeasible grounds for international intervention. Now, in Justice for Hedgehogs, his magisterial book published last year, Dworkin treats human rights as a subset of the general category of political rights. Political rights express the demand of justice that governments respect the dignity of all members of the political community. And dignity, as construed by Dworkin, has two components. First, a community must treat its members' fates as equally objectively important. Second, it must respect their personal responsibility for defining what counts as success in their own lives. But a government can enjoy legitimacy, its laws can be binding on its subjects, even when its laws are unjust. Human rights, however, are those rights which cannot be flouted without impairing the government's legitimacy. Human rights violations constitute not just mistakes regarding the demands of dignity, says Dworkin. Instead, they go further and manifest contempt for the dignity of some or all of the members of society. For Dworkin, a government is legitimate to the extent that it operates on a good faith understanding of what dignity requires. And the touchstone of good faith is acting on principles that constitute an intelligible, even if ultimately flawed, conception of dignity. Now, whether or not this constitutes an adequate theory of legitimacy, it seems to me doubly problematic as an account of human rights. The first reason is that it compromises the idea that human rights confer on all people entitlements to the self-same object, such as a substantive level of health care. This is because judgments as to the good faith of government are sensitive to variations in local political, economic, and cultural conditions. Hence, as Dworkin says, a health or education policy that would show good faith effort in a poor country would show contempt in a rich one. This leaves open the disquieting possibility that IVF treatment, or even some forms of cosmetic surgery, are human rights entitlements in developed societies, while inhabitants of poor countries are only entitled to the most rudimentary levels of healthcare. Such rights are universal only in a highly attenuated sense. Since legitimacy consists in the obtaining of a certain kind of relationship between a particular government and particular members of a particular community, any theory that makes compliance with human rights anything like a sufficient condition of legitimacy will arguably confront similar difficulties in capturing their uniformity of content. A way out of this difficulty is to say that human rights are standards whose substantive content is uniform across societies, but that they constitute only necessary conditions of legitimacy. This is Rawls's approach, but as we saw, it issues in a minimalist schedule of human rights of the sort that Dworkin wishes to avoid. The second objection is that it's questionable in any case that Dworkin can avoid an unduly short list of human rights. The standard of a good faith effort, one manifested by the adoption of an intelligible conception of dignity, seems too lax. For it looks as if many political ideologies that sponsor paradigmatic human rights violations are plausibly interpretable as offering intelligible conceptions of dignity. For example, Dworkin insists that in our age, laws that forbid property, profession, or political power to women cannot be reconciled with women's responsibility for their own decisions, the second component of dignity. Yet it's hardly obvious that deep-rooted ideologies that exclude women from certain public or religious offices on the basis of a supposedly divinely ordained division of labor among the sexes fail to embody even an intelligible, as opposed to just radically mistaken, conception of women's dignity. If this were so, we should be hard-pressed to explain the persistence of such ideologies in the present age, even among members of Western societies. The intelligibility test yields the wrong answers about human rights, I submit, because it poses the wrong question. I turn now to the other influential functionalist view that follows in Rawls's footsteps. Joseph Raz's functionalist theory of human rights is a more modest departure from the orthodox view. It presupposes the existence of universal moral rights, but identifies human rights as a subset of these rights. Human rights are universal rights that satisfy two conditions. First, the state has a duty to ensure their fulfillment, and second, the state's failure to discharge this duty can justify, in principle, forms of intervention by outside agents that would normally be prohibited by a sound principle of state sovereignty. Now, Raz's approach is an advance on Rawls's because it does not require that a human right be such that its violation could justify military intervention. And that was the feature of Rawls's theory, which is most directly responsible for his truncated list of human rights. Indeed, Raz's key argument for his theory is its fidelity to the contemporary practice of human rights. But it's precisely on the score of fidelity that we should resist this view. To begin with, a key explanation of the success of the concept of human rights in recent years is that such rights can be coherently endorsed without thereby committing oneself to any stance on the appropriateness of outside intervention in the event of their violation. Geoffrey Wilson, the British member of the Universal Declaration Drafting Committee, suggested that in the absence of an effective means of international enforcement, the document would become a perpetual source of mischief. In retrospect, however, as historians have shown, this proved to be the key to the subsequent success of the human rights idea, since the great powers would not have supported the Universal Declaration had it included enforcement mechanisms. Now, someone might respond that even if the contemporary human rights practice began by sidelining issues of intervention, this is no longer the case. Such a response would have to reckon with the countervailing evidence provided by the political scientist Beth Simmons. In what is the most rigorous study of the contemporary human rights treaty regime, Simmons shows that the crucial role in ensuring compliance with human rights treaties belongs not to white knight international agents, but rather to domestic mechanisms, such as elite-initiated agendas, litigation, and popular mobilization. Conceptually linking human rights to international intervention flies in the face of these facts that give primacy to ordinary domestic politics over high politics. Finally, and perhaps most importantly, Raz's theory is internally conflicted. In order to ensure a sufficiently generous list of human rights, one that broadly matches the Universal Declaration, he needs an expansive understanding of intervention, one that encompasses forms of action well short of military intervention, economic sanctions, or territorial incursions. Indeed, he probably needs to insist that formal criticism by one state of another constitutes a form of intervention that is normally ruled out by a principle of state sovereignty. But this is an eccentric view of state sovereignty, one possibly endorsed by the Chinese government, but few others. Hence the internal conflict. He cannot be faithful both to the contemporary practice regarding human rights and that regarding sovereignty. And this is because such practice does not embody the idea that human rights are essentially limitations on state sovereignty. If it did, all human rights would be jus cogens norms, which they evidently are not. Let me conclude my discussion of these two variants of functionalism by mentioning a general problem with functionalist views of human rights that make the concept of a human right parasitic on the idea of the state, with its claim to legitimacy, or that of a system of states subject to a regime of intervention. The problem is that the language of human rights is often deployed by those implacably opposed to the state or to its assertions of legitimacy, such as philosophical anarchists, and also by those who believe that we should abolish the state system in favor of cosmopolitan one-world government. It's decidedly odd, if not strictly incoherent, to ascribe to such people, who have perfectly intelligible reasons for supposing that human rights are best fulfilled outside the state or the state system, a concept of human rights according to which it essentially concerns the state or the system of states. The general rejection of a state-centered view of human rights, which I'm advocating, doesn't only make sense of the discourse of anarchists and cosmopolitan theorists, it also resonates with the beliefs of the drafters of the Universal Declaration. A rejection of statism lies behind Eleanor Roosevelt's claim that human rights begin in small places close to home, so close and so small that they cannot be seen on any maps of the world. And it also explains the change in the Declaration's name, from the initial International Declaration to the eventual Universal Declaration. In the words of René Cassin, another drafter of the Declaration, human rights must be conceived in relation not only to the state, but to the different social groups to which one belongs: family, tribe, city, profession, religion, and more broadly, the entire human community. In terms made familiar by Jerry Cohen and feminist writers, what is in question is not merely a legal institutional structure, but a human rights ethos that pervades our lives, cutting across boundaries of public and private, society and state. From this point of view, it gravely distorts the significance of human rights to regard them, in the words of one prominent functionalist, as essentially revisionist appurtenances of a global order composed of independent states. Human rights certainly have important implications for states and the state system, but contrary to the functionalist views we've been considering, their nature does not consist in some specific relation to either of these institutions. Some concluding reflections. In a quest for clarity and rigor, philosophers have succumbed to the allure of foundationalism and functionalism. By adopting foundationalism, they constrain the values that ground human rights, either by excluding interests altogether or permitting only a subset of interests to justify human rights. By adopting functionalism, they characterize the distinctive nature of human rights in terms of certain political functions, in particular those of setting benchmarks for governmental legitimacy or triggers for international intervention. I have argued that these constraints are straitjackets that distort our understanding of human rights. Liberation consists in adopting a more pluralistic view. At the level of foundations, a plurality of values plays a role in grounding human rights. On the one hand, the idea of moral status. On the other hand, the multiplicity of human interests. Similarly, at the level of the normative implications of human rights, we should recognize, as Onora O'Neill has long emphasized, that human rights have implications for a variety of agents and contexts, so that it's a distortion to privilege their implications for the state or relations within the state system in articulating their nature. The picture of human rights that emerges once we renounce the dogmas of foundationalism and especially functionalism is, I think, one that presents strong continuities between human rights and the traditional idea of natural rights. Both are fundamentally moral rights possessed by all human beings simply in virtue of their humanity. Hence, I reject the increasingly popular view that the Universal Declaration ushered in a new concept, a radical departure from the natural rights tradition. Recently, one historian has gone so far as to say that human rights were the creation of events that occurred only a generation ago, in the 1970s. That would be a splendid way for atoning for the various fashion crimes, etc., committed during that decade. Hearing this, however, I feel something like the way Bernard Williams did about the claim made by an incautious historian of science, that quarks were created by the activities of particle physicists. As Williams observed, the 1970s is rather late for the beginning of the universe. Partly these historians are led astray by functionalism, but the deeper point is that human rights morality is not in the first place a code, but a distinctive moral sensibility. And moreover, it's a sensibility we have good reason to believe reflects moral reality. Indeed, this is a vital commonality between human rights and natural rights. Both purport to be truths apprehendable by ordinary or natural reason, as opposed to being the deliverances either of revelation or products of social decision? If so, it would be extremely surprising were no intimation of these truths ever vouchsafed to anyone prior to the 1970s, or for that matter, the 20th century. And indeed, the best historians of human rights confirm these suspicions. Brian Tierney, in his magnificent work, The Idea of Natural Rights, regards human rights as essentially natural rights and traces the dawning of natural rights thoughts to the humanistic jurisprudence of the 12th century that sought to reconcile canon law and Roman law. Others find a human rights sensibility in the writings of the classical Roman jurists, while still others push further back to Aristotle. Well, I shouldn't be surprised. But most contemporary historians regard neutrality as to the truth of moral propositions as an unshakable methodological tenet. Like the religious skeptic Edward Gibbon, whose explanation of the dramatic rise of Christianity in ancient Rome diplomatically set aside the influence of truth and reason on the one hand and divine providence on the other, they believe an account of what human rights are and how belief in them arose must be given without taking a stand on whether they embody true requirements of morality. In this arm's-length relation towards the moral truth, they have found allies among the philosophers. And here I don't mean those self-described critical theorists who question the very idea of objective truth, a position that, as Plato showed long ago, toys with incoherence. I mean John Rawls and his legion of followers, although not, thankfully in this case, Professors Dworkin and Raz. Since reasonable people disagree about the moral truth, Rawls claims that unlike natural rights, human rights must be justified by a form of public reason that is discontinuous with ordinary moral reasoning, levitating above the fray of the interminable quarrels about the truth of morality, human nature, and divinity. To argue on the basis of the supposed truth, says Rawls, is to fail properly to respect reasonable others who disagree with you. I have argued in other work that the beguiling Rawlsian construction is, in the end, a house of cards, one that collapses back into a dogmatic commitment to a liberal democratic perspective. It can therefore provide no real comfort to anyone concerned to fend off the accusation that human rights doctrine is ethnocentric, a hegemonic extension of a peculiarly Western perspective. But the key point about views that bracket the truth is that the first question is not whether we can justify human rights to others, but whether we can justify them to ourselves, we who are already committed to them, or whose commitment to them is wavering or under threat, or who are just wondering whether or not they merit our commitment. And in justifying them to ourselves, how can we stop short of anything but our reasoned beliefs about the truth of the matter? And if this is so in our case, can respect for others consist in anything less than giving them our reasons for taking human rights morality to be true and acting towards them in the light of that truth? Indeed, there are not really two distinct stages here, since the truth is best discovered through a dialogue with others whose beliefs and inherited assumptions differ from ours. However, our ability to act on these truths about human rights will be constrained in certain ways by the content of these rights themselves, naturally, but also by a proper respect for pluralism, for the fact that different individuals and societies may legitimately order objective values in different ways without committing any mistake, and by a respect for their self-determination, even in cases in which we feel a mistake has been made. But respect for pluralism and self-determination are yet further moral truths, along with the truth about human rights, to which we need to be responsive. And yet, when it comes to what we can say to those, sometimes from other cultures, who are not committed to human rights, the pluralist view I've described has its advantages. In virtue of rejecting foundationalism, we avoid presenting human rights as basic, underived moral standards that either you get or you don't, or as reflecting what might be perceived to be a peculiarly Western privileging of the claims of freedom. Instead, the possibility opens up of showing that human rights can find support in any legitimate ordering of the basic interests that are the components of a good human life. In virtue of rejecting functionalism, we resist linking human rights conceptually with particular institutional arrangements or roles. Too often, it is assumed that if a norm is a human right, then certain specific institutional consequences automatically follow. For example, that it ought to be enshrined in a country's constitution and protected by the institution of judicial review, that it is a basis for external intervention in the case of violation, including intervention by international courts whose judgments presumptively trump those of national courts. It is vitally important what stand we take on these questions, but they are questions to be addressed by substantive argument. No answer to them is written into the conceptual structure of human rights. In this lecture, I've argued that human rights are doubly pluralistic. They are pluralistic both in their grounding values and in their practical implications. We should therefore resist the foundationalist and the functionalist tendencies to characterize them in terms of specific grounds or implications. But pluralism does not come at the expense of rigorous thought about human rights. Instead, it is the framework within which that thought unfolds. And as it unfolds, its aim should be nothing less than the truth. Thank you.
We've heard something that is bold, exciting, worthwhile, and will live with us. John, thank you very much.
By virtue of the powers vested in me, I hereby inaugurate Professor John Tasioulas as the Quain Professor of Jurisprudence at UCL.